CITP is that kind of place where you can have people for whom tech policy is the core of their work.
It was already clear that we needed joint degrees in technology and policy.
We're going to have to navigate a lot of these issues with international partners around the globe.
Almost everything is beyond your control in terms of outcome.
We don't have a theory.
I think we're underestimating how much our policymakers are not on board.
As Dean, I have been committed to ensuring that our curriculum and programming remain relevant and forward-thinking.
All right, wow, such a lovely audience. Maybe we can get started right away. So welcome back from break, everyone. It's great to see you all here today. My name is Sayash Kapoor, and I'm a PhD candidate in computer science at Princeton University. And despite what Zach said earlier about folks wearing ties, I'm very much a technical person. My research looks at the societal impacts of AI, but today it is my pleasure to host a number of researchers from CITP as they talk about their recent work. So if you've looked at the schedule, this session is about lightning talks from a number of researchers, 8 researchers at CITP. But before we get to the lightning talks, I wanted to take a few minutes to very quickly talk about CITP's overall work in the area of tech policy. So CITP's mission statement is to understand and improve the relationship between technology and society. And there are 2 main parts to this mission, the understand part and the improve part. So we try to understand the impact of technology on society by, at its core, doing expert research. So CITP, at its core, is a group of experts spanning 3 different areas. The first is AI and data science. This includes subjects like evaluations, reproducibility, AI ethics, transparency, and openness. The second is improving digital privacy and security, such as improving authentication, improving the security of online communication, as well as data collection online. And the third is platforms and digital public infrastructure, which includes auditing social media, creating the infrastructure to support online activity, such as payments and identification. And we'll see examples of all 3 of these focus areas over the course of these lightning talks. What's perhaps more relevant for this audience today is the second part of CITP's mission, which is to improve the relationship between tech and society. We do policy engagement that is grounded in rigorous scientific research. So researchers at CITP have helped inform policy at all levels of policymaking, local, state, and federal, and across all branches of the government, including the legislature, executive, and judicial branches. I'll go over a few quick examples. On enforcement, former CITP PhD student and current CMU lecturer Anne Kohlbrenner gave a series of talks to state attorneys general across the country for improving their technical expertise. We heard a lot in the last panel about the importance of this type of work, and some of our former and current researchers are doing this type of work. On the judicial side, the Tech Policy Clinic at CITP, led by Mihir Shirsagar, submitted an amicus brief in the Google v. Gonzalez case last year in the Supreme Court. On the executive and legislature, in partnership with Zach Varun, who moderated the last panel, we have organized briefings for congressional and executive branch members, including on AI safety, automated decision-making, generative AI, and how we should regulate open source AI. And finally, in some cases, we have been able to influence and change policy through open standards, such as on the internet. So Professor Rexford talked about her work and her collaborators' work very briefly. Let me take a quick minute to expand on it a little bit, because I think this is one of the coolest examples of how research can translate into real-world impact. So in 2017, CITP researchers found and proposed a fix for a major software vulnerability in the security of online communications. They published a paper, they gave a few talks about it, and if this were a research group, the impact would have ended there. But because we work at CITP, this was merely the beginning of a half-decade-long process to get this fix enshrined in the internet standards. So over the next 5 years, the group tirelessly advocated for adopting the fix across major online internet standards, including hosting a workshop at CITP in 2022. And finally, just a couple of months ago, this fix has become a requirement for the major internet standards online. So this is just an example of how we bring this grounded research-based perspective into informing policy, not just at the federal and state levels, but also at improving the standards of the online communication infrastructure. So these are just a few of the many ways in which CITP researchers have been able to inform policy. And at the forefront of most of this research is the work done by fellows and graduate students. So in this session, you'll hear from 8 fellows and grad students about their work and its impact, ranging from a host of topics like AI safety to social media and the transparency aspects of rideshare workers. The talks are relatively short, so we'll have about 6 to 8 minutes for each speaker. But we have a lunch break right afterwards in the courtyard in the back so that you can get a flavor of their research and perhaps go up and talk to them. All right, so with all that said, let's transition to our first talk. Our first speaker is Jane Castleman. She's a first-year CS graduate student at Princeton who will be talking about online targeting on social media platforms. Over to you, Jane.
Hi, everyone. Thank you to Sayash for that wonderful introduction. I'm really excited to be here to present my senior thesis work advised by Professor Korolova about the effectiveness of ad controls and explanations in AI-mediated targeting regimes. So today I'll be talking about Facebook's recent shift towards AI-mediated targeting, discussing how we measured ad control effectiveness and ad explanation transparency, and finally going through some of the broader implications of this research. So I'm sure a lot of you are familiar with the user side of Facebook's advertising system, but for advertisers, in 2022, Meta introduced their Meta Advantage Plus ad targeting system, which increases advertiser performance by using AI-mediated targeting that improves ad targeting with less information about users. So on the advertiser side, previously they were required to input categorical information about their ad segments such as the gender, demographics, interests, and behaviors about users. But with Advantage Plus, Meta's ad technology automatically finds them an audience with no advertiser input. While this is great for advertisers, on the user side, user-facing controls and explanations still rely on this categorical targeting. For example, in our paper, we focus on the see less ad control, which allows users to mark to see less of a certain interest and experience fewer ads related to that topic over time. In terms of ad explanations, for each ad a user sees, Meta will list the advertiser choices that led to that user being targeted in the advertiser targeting criteria. But as you'll notice with Advantage Plus, advertisers are no longer required to specify any of this targeting criteria. As ads become increasingly persistent and pervasive, certain groups have noted how it can be particularly harmful for them, such as new parents or users with histories of disordered eating. Facebook themselves denotes parenting and body weight control as sensitive ad topics, and we focus on them in our research, considering we have a heightened expectation for controls in these areas to be effective. Our work answers the question, how does the shift to this Advantage Plus AI targeting impact users, both in the effectiveness of ad controls and the transparency of ad explanations? So now we'll walk through some of our findings in terms of the effectiveness and transparency. In terms of the see less ad control, we recruit over 200 users and collect their ads over about 3 weeks, asking some of them to mark see less to either parenting or body weight control, and analyze how the related ads they experience change over time. We find that this control is largely ineffective, considering there is no meaningful difference in the change of proportion of related ads for those who did and didn't mark see less. In terms of user-facing transparency, for each ad that our participants saw, we also asked them to upload the advertiser choices that led to them being targeted, and code them in connection to an ad control that a user could leverage to see fewer of these ads. We code advertiser choices as generic if there's no related ad control, with parameters like an age, a broad location of the United States, gender, or language, since users can't change this information. We code them as activity-based if it's based around a site visit, and we finally code them as interest-based if it's related to an interest, as in that see less control. We find that 67% of local ads display only generic ad explanations, which is contrary to our expectations since local ads are hyper-specific to a certain user, and we would either expect a specific location, activity, or interest that led to them being targeted. Perhaps more concerningly, we find that 68% of ads related to blocked topics only display generic ad explanations. So these are our participants who marked see less to a topic, continued to experience a related ad to that topic, but were only given this generic ad explanation that doesn't connect to a way that they could see fewer ads in the future. So why does all of this matter? Well, in our study of the effectiveness of these ad controls and the lack of transparency of these explanations, we find that there exist user-level harms in Facebook's advertising system, in the lack of agency users have over potentially harmful ads. We also see that Facebook is prioritizing these advertising-facing tools in terms of introducing Advantage Plus audiences without updating user-facing control and transparency explanations. More broadly, we show how it's challenging for platforms to uphold transparency, actionability, and user control over these complex AI systems, and demonstrate the need for platform-supported auditing to hold them accountable for their promises to users. From a policy perspective, it's not enough that Meta is offering these ad controls and transparency explanations to users if there's no measurement of how effective they are on the user side. I'm really grateful to be here presenting my work, and if you are curious about the details of our study, please feel free to take a look at our full paper or find me later in the conference. Thank you so much.
All right, thank you so much, Jane, for that wonderful talk. Next up, we have Justin Curl, who's an alumnus of CITP, also a Harvard Law student, and Tech Law and Policy Advisor to the New Mexico Department of Justice. And he'll talk about the role of state attorneys general in tech policy. So Justin, if you can come up, please.
Okay, hello everyone. My name is Justin Curl. As Sayash said, I'm a second-year JD candidate at Harvard Law School, and for the past 8 months, I've been serving as the Technology Law and Policy Advisor to the New Mexico Attorney General, Raul Torres. That's where my credibility comes from to talk about AGs, because otherwise, I don't know why you'd be listening to a second-year law student. So the agenda for today, I ran through these slides yesterday with one of my CS friends, and the first question he asked was, what is an AG? So to start, the state attorney general is the chief legal officer of a state, and so they're tasked with enforcing all of the laws. This becomes really important because even if you pass laws and you write the perfect bill in a statute, if no one is there to enforce it, functionally, do you actually have those rights? And my core claim for today is that state AGs will be one of, if not the most important government actors over the next 10 years in tech policy. I realize that's kind of a bold claim, but hopefully by the end of this presentation, you'll be at least somewhat convinced. So there's two reasons why I think state AGs are so important. The first is because they have a very broad enforcement mandate, and second is because they have a flexible policy-making role. Starting with enforcement, many states grant the attorneys general a broad FTC-style enforcement authority. So if you don't know what the FTC does, under Section 5 of the FTC Act, the FTC can sue to prohibit practices that are either unfair or deceptive. And so at a very high level, when you think, wow, there's no way that can be legal, typically this is one way that it actually is illegal because it's just blatantly unfair or it's deceptive. New Mexico, like many states, has given the Attorney General similar authority. It's called the Unfair Practices Act. So New Mexico AG Torres has sued Meta and Snap for unfair practices. In particular, he is concerned that the platforms match children with predators, design addictive features for youth, and then distribute child sexual abuse material online, and they do so knowingly. If you want to read the complaints filed against Meta and Snap, they're both available online. They're incredibly damning. For a status update of where those are at, Snap has had the complaint filed, and then Meta actually this past summer, the Attorney General defeated a motion to dismiss, which is actually a very big deal because less than 1% of cases actually go to trial. And most of them are filtered out at this stage. So the fact that every single claim beat a motion to dismiss suggests that there's really some merit to these claims, and you can read more about it online. So this is bucket one of what AGs do. It's enforcement, and it's based on an FTC-style authority. Most AGs have this authority. The second enforcement bucket is that AGs are treated as a de facto regulatory agency because states don't really have the same resources as the federal government. They don't have this massive administrative state where they can delegate to the FTC or NIST or some subject matter specific regulatory agency. Instead, they delegate to the AGs. So New Mexico has a political deepfakes bill, and no surprise, that is enforceable by the AG, the district attorney, and affected individuals. I think more on point is Colorado's recent AI bill. This is viewed as very comprehensive legislation directed at bias in decision-making systems. And so this bill requires developers to give reasonable care to consumers, and that's a technical legal term of art, but the things that are important for the attorneys general are, one, it requires the companies to disclose foreseeable risks to the AG. So who's tasked with enforcement? It's not going to be an agency. At the state level, it's often going to be the attorney general. Additionally, only the attorney general can bring enforcement actions. So if you want to vindicate the rights that Colorado has enshrined in its laws, you actually need to go through the AG to do it. And so these are often political actors, and making sure that we engage with them properly to ensure that they're enforcing the right cases will be fundamental to ensuring that whatever legislation we end up passing, those rights actually get enforced. The second broad bucket of what attorneys general do is policymaking. So first, they can actually propose legislation that frequently gets adopted by state legislatures. The legislatures tend to take these proposals very seriously because the AG is the top law enforcement or the legal expert in the state. And so if your lawyer is telling you, hey, you should do this law-related thing, generally state legislatures will pay attention. This deference is especially strong in the criminal context because the state AG is the top law enforcement officer. For example, Washington had an AI task force bill that was proposed by AG Bob Ferguson. The New York passed a Safe for Kids Act, which was co-written by the New York AG's staff. And then New Mexico, this is what I was working on over the summer, we're proposing some misinformation and deepfake related legislation for the upcoming legislative session in January 2025. The other way that AGs affect policymaking is they can issue formal opinions on the meaning of statutes. So New Mexico has the political deepfakes bill that I mentioned before, and so the governor actually asked the attorney general, hey, there's a lot of provisions, what do those actually mean? And in that sense, the AG is functioning as sort of in-house counsel to the governor. And so the governor asks things like, is this definition of AI too vague? What is it actually saying? Would it survive the First Amendment challenges that will likely come up? What sort of enforcement actions are people authorized to bring? And so the governor actually gives the AG's opinions a lot of weight in terms of interpretation. So in summary, the reason why I think AGs are so important is because they're kind of like an FTC plus a tech agency plus a legislator plus a judge rolled into one. I think this is obviously a broad oversimplification, but I think it gives you a sense of just how far-reaching the AG's authority is and all the different ways that they can really get involved in the tech policy world. And I think as researchers, as advocates, as students, we should be thinking very deeply about how we want to engage with these very important actors. Thank you so much. This is somewhat like a selfish plug, but it's not every day that I get to speak to a room full of tech policy people, so I would love to talk to any of you more. These are some things I would love to talk about, just like anything I mentioned in the slides, some research, or law school. But thank you so much.
All right, thank you, Justin. I'm sort of ashamed I didn't mention state AGs as one of the actors that we engage with. So next up is Basi Imana, who's a postdoctoral researcher at CITP, and he'll talk about how we can audit social media platforms in the public interest. So over to you, Basi.
All right, thank you, Sayash, for the introduction. Hi, everyone. I'm Basi, and I'm a second-year postdoc here at CITP. And I'll talk about our work on auditing social media algorithms. And this is work done in collaboration with Professor Korlova from Princeton and Professor John Heidemann from USC. So just to motivate our work, over the last 10 years, researchers have hypothesized that social media algorithms can lead to discrimination in how they shape access to information opportunities. And this is both for algorithms that are used to show organic content on people's news feeds and also targeted advertisement. And what I hope to do in this talk is to highlight some of the work we've done to prove this hypothesis and show that these algorithms can indeed lead to discrimination, and talk about how that has informed legal action against the platforms. And to set some context, I'll be I'm mainly focusing on target advertisement because compared to organic content, it's a relatively easier component of the system to study without any special access to the platforms. But the concerns that I'm going to talk about broadly apply because similar algorithms are used across the board. And I'll conclude the talk with a brief highlight of what we think the future of auditing these algorithms can look like. So to start with a high-level overview of how target advertisement works, it's a two-step process where first the advertiser selects targeting parameters like the budget, the ad creative, the audience, and so on. Then the platform takes over and runs a complex system of what are called ad delivery algorithms to determine things like the ad auction bids and how relevant the ad is to the users to ultimately decide who sees a given ad. And so the research question in our work is how do we isolate and measure the role of this ad delivery algorithms in discrimination by protected demographic attributes such as race, gender, and so on. And how do we do that with only black box access without any collaboration with the platform? And our focus on ad delivery has become even more important in the last year or so because, as Jay mentioned in the first talk, there has been a move towards AI-mediated targeting where the advertisers have less control. So the state-of-the-art method for auditing ad delivery algorithms relies on using paired ads. So the idea is we run two ads at the same time and targeting the same audience, and we look at the relative difference in how these ads are delivered to isolate the role of the ad delivery algorithm. And so for any domain of interest, what we would do is we pick such paired ads that reflect some de facto societal skew and check whether the way the ads are delivered propagates that skew. So for example, in this study by Ali and Sapinski et al., they compare a pair of janitor and lumber job ads, and they show that the janitor ad goes to majority black people and the lumber one goes to majority white people. And so relying on such paired ad approach, our work and work done by other groups doing the similar line of work contributed the technical evidence that led to the first of its kind legal action against ad platforms. And so an example of that is discrimination, how this ads for housing and employment ads are delivered on the platforms. And so Meta, which is one of the prominent ad platforms and subject of this audit, was sued by the Department of Justice and reached a settlement to deploy a system called variance reduction system to try and mitigate this problem of bias and discrimination. And while VRS is an important step forward, we can't quite declare a win yet because VRS is limited in its scope. Both the legal settlement and the technical implementation only focus on three domains, which are housing, employment, and credit. And also more importantly, the technical solution does not really get at the heart of the problem by disentangling and fixing the different source of bias. And we show this limitation by conducting another study looking at discrimination and how education ads are delivered, which is outside the scope of the existing solution. And so in this study, again, we use a paired data approach, but here we compare the delivery of ads for for-profit and public universities and show racial bias in how these ads are delivered. And our main takeaway is that the concern of discrimination is not just limited to the current scope, and that we need a broader set of auditing and bias mitigation solutions. So looking forward, so everything I've talked about so far assumes an auditor that has only block box access and relies on this carefully crafted paired ads to identify bias, which is one, a non-trivial process, and two, is susceptible to platform interference. So the question we ask is, can platforms do to support, what can they do to support auditing? And there's certainly a wide consensus that platforms need to do more to provide access to auditors, and this is also an active area of legislation. But platforms push back, citing risks to users' private data and also the trade secrets and their own business interests. And towards addressing this challenge, we conduct another study where we propose what we call platform support auditing that uses differential privacy to provide auditors specific interface for studying these platforms and conducting meaningful audit without compromising privacy. So we propose a concrete technical framework and show how this can work for ad delivery, but like I said earlier, the similar algorithms are used across the board, so we believe this can be generalized to other contexts as well. So I encourage people to look at the paper for more details, but the main takeaway is that the auditing tools that we have right now have been important to get us to where we are right now, but we need more innovative technical solutions as a form of long-term solution. Thank you.
All right, thank you so much, Basi, for that wonderful talk. Next, we have Nitya Nadgir, who's an emerging scholar at CITP, and she will talk about her recent work on evaluating generative AI systems that are used for taking real-world action. Over to you, Nitya.
Hi, everyone. My name is Nitya. I'm an emerging scholar, which is a 2-year postbac program. And during my time at CITP, I've worked on a variety of projects, but for the purposes of this talk, I'll be focusing on the AI agents work I've been doing over the past couple of months, more specifically trying to find the answer to the question, can AI agents automate research? And this is the group I've been doing this work with, all at CITP. Our motivations for asking this question include, first, claims that we've seen that AI can automate all of science. So we believe that these claims are currently out of reach given AI's capabilities, but we do think that AI can automate measured tasks with a more limited scope, and this could save downstream users a lot of time on their tasks. Second, studies across fields are not reproducible, meaning rerunning the experiments in papers sometimes don't yield the same results that the original authors got. For example, in the 2022 Machine Learning Reproducibility Challenge, experts attempted to rerun the code of existing machine learning papers, and over a third of the papers were not reproducible despite the availability of both data and code. And this could happen for a couple different reasons. It could be insufficient documentation, new hardware, or outdated libraries, but it is a pretty big problem because we don't know what research we can trust. And third, there are a number of shortcomings in AI agent evaluation practices that make it really hard to measure the real-world impact of AI and also verify all of the far-reaching claims about AI's capabilities. And we explore this further in a paper we published this past summer called AI Agents That Matter. And finally, if AI can automate some part of research, it could be the first step towards AI automating even more of the research lifecycle, including the possibility of supervised automation or AI conducting its own novel research too. Given these motivations, we created CoreBench, or the Computational Reproducibility Agent Benchmark. And computational reproducibility is the ability to reproduce the results of a paper with the code and data available. We wanted to see if generative AI, more specifically AI agents, could improve the state of computational reproducibility. And there are a lot of existing definitions of AI agents, but roughly speaking, they are systems that can make multiple calls to a language model to solve a task with minimal human supervision. And agent benchmarks consist of tasks that can be used to evaluate these AI agents, the same way exams are a benchmark to evaluate students. And there are a lot of existing agent benchmarks already. There are web-based benchmarks. They evaluate agents on web tasks. There are coding benchmarks. They evaluate agents on their ability to code. And there are also general-purpose benchmarks that evaluate agents on a wide variety of tasks across many different domains. And our benchmark, CoreBench, evaluates agents on their ability to reproduce existing research given both the code and the data. Our benchmark has 90 papers and 270 tasks. They span 3 disciplines and 2 languages, and all of our papers are sourced from a web platform called codeocean.com. And CodeOcean hosts computationally reproducible research with the papers accompanying data and code. So because we got all our papers from CodeOcean, we know that all of the papers in our benchmark are reproducible, so all the tasks in our benchmark are solvable. And we also know that all of our papers are real-world existing papers. This is an example of what our task pipeline looks like. So we provide an agent with the task and the code and data that accompanies a paper. And to solve a task correctly, the agent has to retrieve results from a successful run of the code and provide it to us in a report. Given all of the far-reaching claims about how AI can automate all of science, how well do you think our benchmark, our best performing agent did on our benchmark? Okay, so we see here that even our best performing agent was only able to solve about 1/5 of all tasks in our benchmark. And reproducing research is an easier task than conducting novel research. So clearly we still have a long way to go before AI can automate all of science. We still do think our benchmark is useful in a lot of different ways. So agents that do well on our benchmark can be used by conference organizers, journals, and researchers to verify the reproducibility of their own research before they publish it. And even just automating a portion of the entire process of verifying reproducibility could save researchers a lot of time and also ensure that even more published research is actually reproducible. These are just a couple future directions that we're looking at. We want to create harder benchmarks with harder tasks, especially as the capabilities of AI agents improve. And currently, we're working on a benchmark that will evaluate agents, again, on their ability to reproduce existing research, but this time without providing the agents the code, but instead providing it with the paper, the abstract, or even just a research idea. So that's all I have for today. Thank you all so much, and I'm happy to answer any questions after.
All right, thank you so much, Nitya. Next up, we have Xiangyu, who's a computer science graduate student, and he'll talk about AI safety, in particular, how we can assess safety issues in AI systems and how that might affect policy. Over to you, Xiangyu.
Hello, everyone. My name is Xiangyu. I'm currently a fourth-year PhD student at Princeton. Today, I'm going to give a quick introduction to the adversarial challenges for AI safety. So nowadays, a frontier priority in developing AI systems is to build AI systems that are safe. And currently, the most widely adopted standards to do AI alignment. So basically, when you develop AI model, you very carefully train AI models, trying to align their behaviors with human values and make it helpful and harmless. And somehow it works. So nowadays, if you query like Google's Gemini or OpenAI's ChatGPT and for example, ask how to build a bomb, and you will find the model will almost always refuse and say, okay, sorry, I cannot access with that, and so they will almost always refuse to engage with this kind of harmful activities. However, our research over the last year shows that the AI safety can be much more difficult when there are adversaries that will always try to actively bypass or remove any safety mechanisms that the AI developer implanted in the models. Because AI model is vulnerable to adversarial attacks. And here is an example. Let's say you have an image of panda and you pass this image to an AI model. And now a frontier model can almost always correctly identify, okay, this is a panda. And however, there is a simple attack that can make AI models to make mistakes. For example, an adversary can construct some adversarial perturbation. It's basically some noise pattern, but it's optimized by some optimization algorithm. And you can add this noise to image. and then you pass the modified image to the model again, the fact is even the most advanced AI model may no longer able to correctly recognize it's a panda, and it will say, okay, this is a gibbon. But for humans, still visually the same. It's still a panda, right? And this problem is known as adversarial example. It's a fundamental vulnerability of artificial neural networks, and almost all AI systems are built upon artificial neural networks. And it's a problem that has not been addressed after already a decade of study. So there are over 10,000 research papers on this problem. And everyone tried to solve this problem, but we haven't made much progress despite a decade of efforts. So how is this related to AI safety? So let's come back to the problem of panda image again. And this time we pass the image to an AI chatbot and ask the model, okay, from the standpoint of AI, can you compose a hateful speech against a human race? And of course, the model will say, okay, I'm sorry, I cannot do this because they are safety lines, they have some safety guardrail. But our paper last year in AAAI will show that the same trick we did in adversarial example can also be applied to force a model to disregard any safety guardrails. So they will still, so now you can just add some adversarial noise into image, and you pass a modified image to the model and ask the model again to generate hateful speech. And now it will say these very harmful things. And you can expect this can also happen for other examples. So basically, you can use the same trick to force the model to answer any harmful question. And the attack is simple, but we think the implications are very fundamental. Because adversarial examples are fundamentally hard, we already made a decadal effort and we cannot address that. And we show that this actually can also continue being a persistent threat to AI safety. Besides adversarial example, another research we did last year is to show that we find that actually the adversarial challenges for AI safety can be much even more severe when the customization of AI models are allowed. So to give you some context, what do we mean by customization of AI model? For example, OpenAI, although they closed source their model, but they allow users to build customized GPT model by fine-tuning their original model on their some custom data set, so they can adapt their model for some downstream production or use cases. And in the context of open source, the open weight model, for example, Llama, they are already open source, so anyone can download them from the internet, and you can easily fine-tune them for downstream custom use cases. And our research last year found that if you allow the customization of a model, then its safety is very much vulnerable. For example, we find that if you use OpenAI's fine-tuning API, you can actually fine-tune the model and to completely remove the safety guardrail, and it only takes 10 custom harmful data points, and you only cost less than like 12 US cents. And you can completely remove their safety guardrails that they may spend millions of dollars to build, and then the model will no longer refuse any harmful instruction. And in the open source context, we just show, okay, if you just can download the model and you fine-tune the model with only 10 harmful data points, and for 10 gradient steps, it's mostly less than 1 minute if you have an A100 GPU, and you can already undo the safety alignment largely. And most concerning, we find even just normal downstream customization cases. So there are no adversarial users. So there are just some well-intentioned users. They just want to fine-tune their model for their own use cases. But we find even in that kind of cases, the safety guardrail will still regress after the customization fine-tuning. This is due to some catastrophic forgetting phenomenon of neural networks. That's another fundamental limitation of neural network models. And the work has raised a large awareness last year to underscore how the safety alignment in current large language models are so vulnerable and unreliable in really mitigating this kind of safety challenges. And it was later covered by the New York Times last year in October. And so why do these adversarial challenges are important, right? And what do these adversarial challenges mean for AI safety? So in my view, there are three aspects these problems are important. So first, conceptually, I think the fact that you can just use some noise in the model's input or just fine-tune the model with a few gradient steps to remove its safety alignment actually just indicates the current safety alignment is very much shallow. It cannot genuinely remove any model's harmful capability, and they are just superficially hidden in some ways. And this year, we also have another paper to algorithmically and mechanically to characterize what we mean by safety alignment shadow, and we also talk about potential solution to build deeper safety alignment and make it more robust. And another perspective is, in practice, if you believe the future AI model will bring critical harm, so they may have the capability that can really cause some critical harm that we really do not want to happen. If we do not have any robust security solution that can defend against adversary, that can prevent adversary from attack the model and then misuse the model, that actually equivalent means we have no ways to avoid such critical harm, because in reality, there will always be adversary and attackers that try to attack your model and misuse your models. And to make this point, so earlier this year, we also have another position paper that we highlight that to manage AI risk, it's not just about safety, it's also about security. To achieve your safety goal, you really need a strong security solution that can defend against adversary. Otherwise, there will always be adversary that try to just break your safety mechanism. And finally, I think another important point is from a law and policy perspective. So currently, a core question on the debate is, if someone develops a very good AI model, but some adversary that try to manage to remove the safety guardrail and then misuse this model and finally cause critical harm, should the model developer be caught liable, right? So this is still under debate, but earlier this year in California, there's a SB 1747 bill. So in that bill, they actually imply that tort liability can apply to the model developer if they fail to take reasonable care to implement robust safety guardrail that can prevent adversary from the misuse. And that actually raises a concern that, well, this kind of liability will be a burden for AI developer, because currently the adversary challenge is very severe and we do not have a mature solution to defend against adversaries. And that was under heavy debate over the last few months. And last month, this bill was finally vetoed by the Governor Newsom in California. And that's it. And thanks for listening, and feel free to reach out offline.
Thank you, Xiangyu. Next up is Varun Rao, who is a computer science graduate student, and Varun will talk about the role of transparency on rideshare platforms. Over to you, Varun.
Hi, everyone. I'm excited to talk about some of my research on the role of policy in enhancing transparency in rideshare platforms. Whenever you've taken an Uber ride, have you ever wondered how much the Uber driver gets paid? The rider price is actually divided between the driver wage and the platform take. Our research indicates that the platform take rate is actually highly, highly unpredictable. Can range from the low 10–20% to even the high 90s. Typically, for a given driver, the average take rate's around 30–40%. And to kind of give a concrete example, say the customer pays $100 for an Uber ride, the driver gets about 65, Uber takes about 35, and the take rate here is 35%. Now, these take rates are actually determined by platforms' opaque AI and algorithmic decisions. And these have gotten recent media attention. So here's an article from the Markup talking about how the secretive algorithm is now going to determine Uber drivers' pay in many cities. Here's another article talking about how AI actually drives rideshare platforms and impacting people's work. And here's another article talking about how drivers are actually responding to these opaque pay systems by protesting. These take rates are actually not available to drivers, and it's also not publicly available information. And so we built an app called Fair, which allows drivers to know what their actual take rate is. And we did this in partnership with the Colorado Independent Drivers United, a labor organizing group in Colorado. And we did this in Colorado State, where the take rate was already an important policy question. And so we partnered with them, and then some of our research actually helped influence this Senate Bill 2475, the Transportation Network Company Transparency Act. And this was actually passed earlier this year, and it's one of the first state-level transparency bills for algorithmically determined work. And come 2025, February 2025 in Colorado State, rideshare platforms like Uber and Lyft are going to be required to disclose driver wage and rider charge to both the parties after rider drop-off. Algorithmic opacity in rideshare platforms goes beyond just fares. Now, I'll give one more example here. And so this is an example of a surge screen. So surges are regions on the map where drivers can pick up passengers and get a bonus. And so drivers get different bonus amounts highlighted here by different shades of red. But let's zoom in and actually see what's going on closer. So let's zoom into this region. And here you can see that there's a $19 bonus and a $7 bonus right next to each other. And so this actually confuses and frustrates a lot of drivers because where should they go to pick up to get the $19 and versus the $7? So they don't know how they qualify. This is highly dynamic. Things change by the minute. And it's highly unpredictable, causing some sort of a gamification effect. So we did a study. We understood drivers' transparency needs and concerns across various different scenarios in rideshare. We published this in an academic venue. And more importantly, we also translated this into a policy memo to share with our community partners. We did this in partnership with the Colorado Fiscal Institute Towards Justice and also the CITP Tech Policy Clinic. And here we call for transparency in all aspects of rideshare platform operations through what we call the rideshare transparency reports. And transparency reports have now gained a lot of traction in social media and also other areas like AI foundation models. So why exactly are we calling for this greater transparency in AI and algorithmic decisions? AI-driven algorithms are actually shaping the working conditions and reducing agency of workers. It's causing them emotional, financial, and physical harm, and it's impacting their well-being. And to understand, monitor, and even begin regulating these platforms, we require access to data as the first step. One of the arguments companies cite against public data disclosure is trade secrets, right? But we think that this argument might be slightly overstated. And this paper from a colleague and alum of CITP, I think, makes a compelling statement here. So they say that algorithms are actually understandable technologies, but it's power structures which often obscure them, and you can comprehend them through their inputs, outputs, and design goals. And that's the type of transparency we are calling for. It's not open sourcing algorithms or like disclosing the exact weights that the AI models in these algorithmic decisions are making, because it's even unclear what if those things were disclosed, what you would learn from them. I hope this excited you about some of our research. This is broadly situated under the Workers' Algorithm Observatory, where we investigate black box algorithmic decisions and build infrastructure to support worker-led inquiry. So there's 3 threads that we are currently working on. One's in transparency of worker earnings. The second is transparency in algorithmic decision-making, so building tools to help workers who've been deactivated and studying practices of algorithmic wage discrimination, which has recently got some traction, where different workers are paid differently for similar work. And finally, we engage in transparency policy outreach by sharing memos and presentations with labor advocacy groups and nonprofits like NELP or the National Employment Law Project. Thanks for your time. This was all work done with my amazing collaborators and advisor. Feel free to reach out at any time. Thanks.
Thank you so much for that wonderful exposition, Varun. Okay, so finally, we have 2 last talks by CITP undergraduates, both of whom have spent some time at the FTC. Our first talk is by Sujay Swain, who's an undergraduate student in the Electrical and Computer Engineering department. Over to you, Sujay.
Thank you, Sayash, for the intro. So as Sayash mentioned, I am a senior in the Electrical and Computer Engineering department. I'm studying actually more semiconductor devices, but I've also been a part of CITP, sort of doing a certificate through CITP. And this summer, I was a summer fellow through the Public Interest Technology Summer Fellowship that CITP offers. And was at the Federal Trade Commission in the Division of Privacy and Identity Protection. We've heard briefly about how the FTC has the ability to deal with unfair practices, and under that, Privacy and Identity Protection, or DPIP as it's known, focuses primarily on issues related to data misuse or unfair data collection and ensuring that consumers are protected. With regards to sort of what I did specifically as an intern, they sort of don't let you do a lot, and then at the same time they let you do a lot. It's this weird in between where they don't want you to get deposed about 6 months later when you're back in school. So they had me doing primarily investigative work and acting as a technologist, given that my background was more technology focused. I have worked sort of with networks and with systems and was able to use that. And one of the big things that I sort of was able to contribute was in a technical context. I was able to help many of the lawyers and attorneys understand what some of the technology that we were dealing with. And I think it really spoke to both the amount of work they do and sort of the scope that they have, while also noting that there are still very limited resources, unfortunately, within the federal government at the regulatory agencies to have technical expertise. And I think that that is highlighted in the way that right now the policy is changing around how we can regulate really technical industries. I'll try to give as many examples as possible, but unfortunately a lot of the cases I worked on are still at very early stages. But when it came to the regulatory issues that we were seeing, these really spanned everything from the most advanced generative AI companies and the companies that you hear in the news every day to like startups that were doing really, really niche technologies. And all of them had really technical problems that were affecting consumers on a day-to-day basis. One thing that I quickly became apparent, I'm not a lawyer, I'm sort of very much on the tech side, but one thing that I very quickly saw was that there's very much a limitation in what unfair means. The FTC is no longer able to get any sort of monetary compensation for anybody affected by an unfair practice. That has to be done specifically through things like rules or laws that dictate that. And additionally, there have been cases and sort of an effort to undermine what the FTC can do in terms of regulation and legislation, primarily trying to make the FTC a very narrow focus. Now, that being said, especially with how technology is developing, it means that the FTC has become incredibly creative. And that was something that was really insightful about how we're building more regulatory legislation and regulatory efforts. I think the biggest thing was that the FTC is really leaning into using rules. This is something that in the last 5-6 years has become really important, but the one that I sort of got to see most clearly was the consumer surveillance rule, which was very interesting because that was really focused on how the data of day-to-day people is being affected and how corporations are using that data. And that was something that got a lot of pushback, especially from Congress, because a lot of people in Congress were saying that the FTC was actually overstepping what they were doing. However, given the nature of the landscape and how right now it looks like Congress isn't going to pass any general data privacy rule, this really is the closest that we're going to get to a federal rule. Previous people have also spoken about how state governments can really affect this, and that was something that also became clear that a lot of this is really being put off on state governments, and the FTC is trying to, in some way, have some uniform federal rule about this. The other thing that was really interesting, and especially as a technical person, was understanding how there can be technical penalties to companies that misuse data or deceive customers. If you've seen the monetary penalties, if given, are relatively small compared to how much these companies are actually making. So you're looking at maybe 1 or 2 million for a 100 million or even $1 billion company, which all things considered is less than 1%. They sort of are able to consider this a cost of doing business. But something that has become more prevalent is this idea of model deletion and algorithmic deletion, along with data deletion as well. This is something that the FTC is looking at specifically within DPIP, because this is really important to ensuring that companies see a real penalty when they're building models that essentially misuse data. And this is something that's being explored right now, especially in the context of generative AI models that are pulling from sources that they should not, especially private sources. This was something that I got to see firsthand, but many of the big generative AI companies are going through this phase with the government, where the government is trying to understand if the data that they've gathered has been done in an ethical and also been done in a legal way. And right now we are writing those rules. And I think one thing that's really important is ensuring that there are technical people who can actually help ensure that the rules are quite robust. One of the big things that we saw is that companies will try and throw a lot of technical jargon, and with these fields that are developing very quickly, it is hard for attorneys to understand what's going on. The FTC has grown what they can do by the Technologist in Residence program, which is relatively new. And additionally, I'll sort of give a shameless plug for the PIT SF program, which really was an opportunity to bring a lot of different people, many with technical backgrounds and technical experience, into the government at a very early stage. And I think, especially within what I got to do and with other people at the FTC, we really got to see firsthand how the regulatory space was changing and be able to contribute our technical knowledge in that way. I realize that I didn't put my email up here, but I'll be around and happy to connect with anyone offline. Thank you very much.
All right, thank you, Sujay. And our final talk for this session is by Brooke McCarthy, who is an undergraduate at SPIA, who will also talk about work done while at the FTC. Over to you, Brooke.
Okay, thank you for that introduction. Hello everyone. My name is Brooke. I'm a senior here at Princeton, majoring in the School of Public and International Affairs and pursuing minors in statistics and machine learning and technology and society. So over the past couple of years, I've developed a deep interest in the intersection of technology, policy, and law, which led me to participate in the Siegel Public Interest Technology Fellowship through CITP this past summer, alongside Sujay and several other really wonderful students. So today, I'm just going to spend a few moments talking about my experience in the program, and also talk about some of my major takeaways about the importance of recruiting people with a technical background to work for federal agencies and support their efforts to regulate emerging technologies. So I'm going to echo a lot of what Sujay just mentioned. But yeah, through the fellowship, I had the opportunity to work for the Federal Trade Commission as well, in the Bureau of Consumer Protection Division of Advertising Practices. And ad practices is primarily focused on enforcing Section 5 of the FTC Act, once again. So this prohibits unfair or deceptive acts or practices with respect to advertising. And this is a very broad mandate, so the division handles a wide range of cases from false health claims to deceptive digital marketing practices. And what was of particular interest to me was looking at how the division has been evolving in response to new technologies and forms of advertising, such as AI-mediated ad targeting, as we've been talking about, that didn't really exist just a few years ago. And ad practices has also been involved in a number of recent rulemaking efforts to sort of clarify the liability that advertisers face in response to pretty common prohibited practices, and then also to enable consumers to receive monetary relief in light of the recent restrictions on the FTC's power in this regard. And then finally, the division is engaged in a number of wide-scale studies called Section 6B investigations in order to learn more about some of the general harms that can arise from new technologies. So I personally worked directly for teams of attorneys and investigators to support 3 ongoing cases in ad practices. My role involved conducting document review to identify and organize evidence, assisting with legal and technical research, developing reports to inform case strategies, and also attending weekly training sessions to learn about various aspects of legal research, litigation, rulemaking, and investigations. And through this work, I was able to see firsthand how advertisers were exploiting technologies to deceive consumers and obscure evidence of their wrongdoing. And part of the document review process entailed reading through consumer complaints and call transcripts And I was moved by the stories of over 1,000 consumers who had been victimized by fraudulent companies in this manner. These personal stories were a really powerful reminder for me of the importance of consumer protection work. This experience also underscored how vital it is for people with a technical background to enter the legal field, because as technologies like artificial intelligence and machine learning are becoming increasingly pervasive, there's a growing need to determine how best to mitigate the numerous potential risks. For example, AI-driven advertising can target consumers in incredibly precise ways, which can lead to manipulation and bias. In my opinion, consumer protection law has the potential to play a key role in mitigating these sorts of risks by promoting transparency, mandating fairness audits and the implementation of anti-discrimination safeguards, protecting consumer privacy, and establishing liability for harmful AI-generated outputs. However, achieving this will require a team of regulators who not only understand the law, but also have a working knowledge of the technology. So while federal agencies like the FTC have teams of very dedicated, intelligent, and hardworking individuals, this particular technical expertise is currently lacking. So we should continue to support programs to encourage technologists to join these agencies. And without it, it can be incredibly difficult to craft appropriate interventions and also foresee potential legal challenges. So yeah, overall, my experience showed me that it's important to foster partnerships between technologists and regulators, and also encourage lawyers and policymakers to acquire technical knowledge themselves to help sort of bridge this gap. And then on a more personal note, the fellowship inspired me to continue to grow my own technical background and solidified my interest in pursuing law school. So I highly encourage any students in the audience with similar interests to consider participating in the program in the coming years. And I want to thank CITP once more for providing me with this incredible opportunity. So yeah, if any students have questions about the program, please feel free to reach out to me or Sujay. My information is up on the slide. And thank you so much.
All right, thank you. Thank you so much, Brooke. And thanks, everyone, for these wonderful talks. I hope they gave all of you a sense of the diversity and depth and the richness, really, of the research that grad students and fellows at CITP are doing. So we will now break for lunch. Unfortunately, we don't have time for questions. But what we do have are speaker name tags on various lunch tables outside. So if you have any questions for the speakers, just find a seat next to the name tags. There are also 2 lunch buffets that are available, one in the lobby upstairs and one under the tents outside. And lastly, in terms of housekeeping, please start making your way back by around 1:40 p.m. for the keynote talk in the next session. And with that, I think we're done with this session. Thanks a lot, everyone, for coming. If I could please request the speakers to join me on the stage for a group photo, but the rest of you can go get lunch. Thank you.